hear you now. Okay.
Sorry about that.
All right. I have Judge Carrick here with me, present in the conference room at the Idaho State Bar. And are you ready to start? Okay.
Here we go.
All right, I'm going to begin the recording and then we can get started.
Recording in progress.
Good morning.
Good morning.
I will call the case of the petition against Jane Doe, Board of Commissioners, Idaho State Bar, John Doe, 2025-18, which is the state bar number, petitioner versus Jane Doe, respondent. The Supreme Court docket number is 53006-2025. And before I'm Judge Carrick serving as a hearing officer today by order of the Idaho Supreme Court that was filed on July 7th of 2025. And that order was entered pursuant to the Idaho Bar Commission Rule 508. And that specifically provides that when there is a grievance petition filed against a member of the Board of Commissioners, the Professional Conduct Board or Bar Council, that it shall be submitted directly to the Supreme Court. And so that's mandatory language. And so what happens is that the grievance then gets sent over to the Supreme Court. Now, that wasn't triggered until the respondent, Ms. Weeks, it was anticipation of her becoming a bar commissioner because she'd been elected to that position. She didn't take the position until July of 2025, but because it appeared that this matter would not be resolved prior to that time, then that invoked Rule 508, and that's why the Supreme Court then appointed me to be the hearing officer and fact finder. And then pursuant to that, I had, first of all, I had received the record in anticipation of this hearing, which is conducted pursuant to the Idaho Bar Commission Rule 509, subsection D. Pursuant to the rules, this hearing is being recorded by, and so I will at this time ask the parties to identify themselves for the record. The petitioner, if you'd identify yourself, please.
Yes, ma'am. My name is Mr. Corey Schweitzer. Today I'm speaking to you on a laptop, and that's why I'm going to keep my video off to reduce the amount of shaking.
Okay, thank you, Mr. Schweitzer. And the respondent, you'd identify yourself.
I am here by myself, Patty Weeks.
Thank you, Ms. Weeks. Now, preliminarily, I want to review what the procedure will be today. And I had entered a scheduling order and a briefing schedule, and that was entered on October 8th of 2025. Mr. Schweitzer, I would like to back up a little bit because I know that in your filings, your submissions, you had been concerned about the clerk having attempted to schedule this review hearing on a date that you had indicated to someone that you were unavailable. I would like to make a record on that just so you understand that once this case was assigned, or this proceeding was assigned to me, which was July 7th of 2025, then it's the hearing officer through the court, as appointed by the court, that is responsible for further processing of the case. However, the order of the court is also that the State Bar assists in the facilitating of the review hearing, and so that includes clerical functions and maintaining the record, which is also filed with the Supreme Court. So when I was trying to schedule this, it had been filed July 7th, and so in the interest of moving the matter forward, I had proposed some dates that I was available in October. I had no information about what you may have filed relating to your other grievance actions that are being processed by the State Bar under 509 of the rules. And so when the response was that you weren't available, then we took into consideration your availability, working with my schedule, your schedule, the schedule of Ms. Weeks, and this is the day that we came up with. And so I want to just make a record of that. So in terms of someone deliberately ignoring your availability, I had no information because I wasn't privy, at least at that time, to any kind of assertion by you that you were not available on those dates, and that was a tentative proposal anyway. So that should clarify that matter for you. Once I...
Your Honor, may I?
Just a sec. Yeah, go ahead.
I have 4 specific things, and if you would like to continue with my other grievances in my objection, we can continue that now. If you would prefer I address the Karen Carlisle conflict now, we can also do that.
No, let's go ahead and let me make the record in terms of the procedure.
Yes, ma'am.
And then you will get an opportunity, as I provided for in the scheduling order. You will have 20 minutes, maximum of 20 minutes to make your arguments. Ms. Weeks also will have the same maximum amount of time on the original or initial presentations. And so
I understand.
So what I want to do though is go over what the scheduling order provided, and that is that there was a deadline for additional written documentation to support or refute the original grievance to be received by the clerk of the Professional Conduct Board no later than October 27th of 2025. And those submissions must be limited to allegations being reviewed. No new allegations of ethical violations will be considered. Number 2, because the parties have been granted ample opportunity to submit their claims and responses in writing, in the discretion of the hearing officer, which is allowed under the rule, no additional written materials or submissions may be presented at the review hearing. Each party may file one brief with the clerk of the Professional Conduct Board to be received no later than November 3rd of 2025. Failure to comply with the definitions shall result in the content of the late submitted briefs and or written materials not being considered. The hearing officer will then render a decision based on the existing record and any arguments presented at the review hearing. And then I have set forth the time limits that apply. So I I want to make sure that both parties understand and have reviewed that scheduling order. So, Mr. Schweitzer, have you reviewed it?
Yes, I have yes, Your Honor, I have read that scheduling order.
Okay. And then you reviewed it?
Yes.
Okay, thank you. Now, I have been, as I referenced, I have been provided with the written record in this matter. So everything that's been filed has been made part of the record, and I've had the opportunity to review it. It consists, included in that is the initial complaint that was filed on May 9th of 2025, correspondence to and from the Idaho State Bar with the parties. There are also the pleadings that have been filed, Mr. Schweitzer, by you with the Idaho Supreme Court. And then the Bar Council's disposition or decision, that was May 29th of 2025. And then your request, Mr. Schweitzer, for review, which was, and a request for hearing, that was by email on May 29th, the same day of the disposition, your response in which you outlined your specific challenges to the disposition. So now Mr. Schweitzer, in referring to the record that the matters that you have filed before the Idaho Supreme Court, it appears that there is one matter that hasn't been ruled on, which is an order to show cause that you had filed on October 27th. And as of Friday, that had not been ruled on by the court according to the court record. And so I have reviewed that pleading. I think primarily the issues relate to your other cases. You have filed an objection and some complaints about some of the procedural aspects that arguably relate to this case. But most of it, at least in the most recent filing of the October 27th, 2025 filing with the court, really the primary issue that arguably relates to this is your complaint about Ms. Carlisle as and her function as the clerical assistant to the hearing officer in this proceeding. So you'll get a chance to address that. But so what my plan is today, I felt like, first of all, this grievance was filed more than 6 months ago. It was assigned to me more than 4 months ago. And it wasn't, because of the challenges in scheduling the matter, I felt that there was in order for the parties to have a reasonable time in which a decision is rendered, so it isn't hanging over everybody, that what my intention today is to go forward with the hearing. I am going to reserve ruling until after the Supreme Court addresses the order to show cause. I will not enter any kind of decision until after that order to show cause is addressed. But we're perpetuating the testimony. We're conducting the hearing. And if it turns out that the Supreme Court's decision on the order to show cause has no applicability to this proceeding or is denied, then I will then issue the decision based on what is presented today, plus what is in the record. So that way we aren't giving up a hearing date, because they require preparation, as you know, both of you, to go over and review your notes, your records. They require preparation for me, so that these numerous documents I feel comfortable in knowing what's in them and how to access them. And so I will note that all of the prior motions have been denied by the Supreme Court. So there isn't anything outstanding relative to anything that was filed prior to October 27th. So procedurally, that is how we're going to go forward.
Ma'am,
Now,
Your Honor, I must wage 4 objections in time when I have my opportunity to move forward, and reasons in which why I do not believe this is an impartial case. I'm sorry for interrupting you, but I need to lodge these 4 objections when I am allotted that time.
okay, and we are just getting to that point, sir. I'm going to have both of you sworn or affirmed by the clerk to present testimony in this matter. And so, Mr. Schweitzer, I'm going to have you, if you would, just briefly turn your camera back on so that we can see you. Great, thank you, sir. And if you would, go ahead, Madam Clerk. Oh, well, I can do it. I'll go ahead and, do you solemnly swear or affirm that you can raise your right hand, just both of you. You solemnly swear or affirm that the testimony that you're about to present in this matter is the truth, the whole truth, nothing but the truth, so help you God, or subject to the pains and penalties of perjury?
I do.
Mr. Schweitzer? And Ms. Weeks?
I do.
Okay, thank you. All right, now, Mr. Schweitzer, you have 15 minutes to present your arguments, both your procedural arguments and the substantive arguments that relate to your complaints about Ms. Weeks. And I had taken some notes on your specific about what Bar Council had failed to recognize. So if you're wanting to address that any further, you will need to include that in this time. But so your 20 minutes starts now. Thank you.
Thank you, Special Master. Before addressing any merits of Ms. Weeks, I must state the foundational objections. This proceeding is structurally compromised and void ab initio. What we have is documented proof of multiple unaddressed conflicts. First of all, Chief Justice Bevins has an intimate relationship with the Idaho State Bar, attended the Idaho State Bar function in Lewiston. That itself is impartiality is questioned in that previously denied motions. Second of all, the administration by material witness Karen Carlisle. Besides being a witness to the Coleman-Turner conflict, which is in one of the pending writs before the Idaho State, actually 2 of the pending writs before the Idaho State Supreme Court, there was a previous scheduling in which I had given my scheduling availability to Miss Karen Carlisle, and it was patently ignored, and opted for the one in which she selected, despite my objections as documented in email.
Okay, now which date are you talking about?
I am sorry, can you please repeat yourself?
What date are you talking about that she ignored your
Yes, ma'am. Let me pull up the Bates number for that and the page on the supplemental record. I believe the dates that I had provided my availability were in the beginning of August. I had sent those to Karen Carlisle in the beginning of August of this year, stating
Did
that was
did that relate to this case or one of your other cases?
it happened to relate to the Trey Turner and Justin Coleman conflict, for which there hasn't been a tribunal approved withdrawal yet.
Okay. All right.
Karen Carlisle was first a witness to the Turner Coleman conflict. Then, without tribunal withdrawal, Turner and Coleman, Karen Carlisle tried to schedule the meeting outside of my availabilities. Then, this meeting on October 8th, which brings up the third one, or I'm sorry, the second part of my second objection is that Karen Carlisle then scheduled this hearing without me saying, yes, we can go do this. Instead, the Idaho State Bar is refusing to release any investigative material regarding Deanna Tollefson. She said that there was an investigation that was performed, but the only investigative documents that have been released to me are the ones that I've generated. Otherwise, they have been responses from the Idaho State Bar. And the fourth institutional conflict is the admitted in the June 20th Purtle letter. While Patty Weeks is the incoming bar commissioner for the 2nd District, Patty Weeks has been the bar commissioner for much longer than that time, which elevates the heightened responsibility for her to investigate the other claims, the other merits of my grievance. Before we even address the foundational...
Let me ask you a question. When you say she was a bar commissioner before July of 2025?
Yes. Bar commissioner for the 1st District. Yes, ma'am.
So she was a state bar officer? Is that what you're trying to say? A district officer, not a state bar officer?
She was the state bar commissioner for District 1, I believe, and was elected to the state bar commissioner District 2 position. It was before that election of the state bar to the 2nd District in which that I had filed that grievance, and under which then they heard it on the basis of that second appointment or election to the bar council.
Okay, all right. I think I understand what you're...
So Patty Weeks has already been the bar commissioner before I even filed the grievance. They dismissed the grievance on the predicate that she wasn't even the bar commissioner yet, and that's an incorrect legal standard.
Okay, thank you.
You're welcome. Second, let's see here. Do you have any other questions? Otherwise, I'm going to continue.
Well, I guess I do have one other question. When you talk about Karen Carlisle being a material witness
Yes.
in this Coleman and Turner conflict, what does that have to do with the allegations against Ms. Weeks?
Ms. Weeks works intimately with Justin Coleman, as Justin Coleman is a Nez Perce County prosecutor. April Smith is the deputy prosecutor in whom I have another writ of mandamus against the Idaho State Bar. So I have Idaho State Bar with Nez Perce County, April Smith, Justin Coleman, and Patty Weeks. Patty Weeks intimately works as the clerk of court and election supervisor with those two specific people. Actually 3, since Trey Turner is a regular opposition in Nez Perce County.
All right, so now who's Trey I know you've got a complaint against him, but what is his role in relation to these other 2 individuals?
Trey Turner is a lawyer working for Clark and Feeney at the train station across from the courthouse, or at least the previous courthouse in Lewiston, Idaho. Trey Turner is a regular opponent in Nez Perce County Court, of which Ms. Weeks regularly interacts with Mr. Turner. Likewise, Ms. Weeks has an intimate working relationship with Justin Coleman and April Smith, as well as Nance Cicerelli. For the record, I would have filed a claim a grievance against Nancy Cicerelli if I thought it would have done any good with the Idaho State Bar.
And what's her position?
Nancy Cicerelli is the chief civil deputy prosecutor for Nez Perce County.
Oh, okay. All right. All right. Thank you.
You're
So
welcome.
I don't have any other questions so far. So you may
Okay.
proceed.
Thank you. Well, because of these due processes isn't satisfied by mere rulings. There was a crucial error in the November 14th denial order that contains multiple legal errors, including false timeliness claims. With the failure to apply the Judicial Conduct Canon 211. That's why I'm explicitly protesting solely to preserve this objection, is that it requires, when there's an intimate conflict, the working relationship with each other, it requires some division of that, where there's some independent investigation, some independent judiciary. That is what our whole judiciary is founded upon, is the whole idea of fairness. And this has multiple conflicts of interests. It's a judicial admission that destroys any claim of fairness. The Bar Counsel Pirtle explicitly admitted that Patty Weeks' status as a commissioner-elect creates a severe conflict that it requires bypassing the normal disciplinary process. But
Well, that's provided for in the rule.
right, but
508,
it
specifically-
existed well before Tollefson ever got her hands on it. You understand what I'm saying? Is that as
No,
soon as
the investigation took place prior to the Ms. Weeks becoming a bar commissioner and the disposition. But what you're contending is that it should have been turned over sooner.
it should have
Is that
been
what you're
turned over,
saying?
it should have never touched the Idaho State Bar's hands, first
Okay.
of all. But second
All
of
right, so
all,
now-
there was no investigation performed.
Okay.
That's my contention, that there was no investigation performed. In fact, all four of my grievances against Nez Perce County were closed on May 29th between Patty Weeks, Justin Coleman, April Smith, and Trey Turner. That is way too coincidental, especially given an unwaivable conflict of interest. There's more than just that going on, Your Honor. So I'm going to continue.
You may. Go ahead.
These aren't just constitutional violations. They're structural due process defects. They're not technicalities. They're fatal flaws that void the entire proceeding. As the Supreme Court held in Caperton versus Massey Cole, certain conflicts create a probability of bias too high to be constitutionally tolerable. We have multiple such conflicts here, including one at the bar has already admitted would be fatal if they were hearing it in their own context. This shouldn't be heard here. The only constitutional permissible course is to stay these proceedings until a neutral administrator replaces Karen Carlisle for scheduling. Judge Janelle Carrick, I respect your position, but your tangential relationship and appointment by Chief Justice C. Richard Bevins, after his intimate relationship going to parties and such in Lewiston, it creates an I'm sorry. Until that's produced, the Tollefson file is produced, if there was one that existed in the first place, if there was any investigation done, and the inevitable Supreme Court appeal rules on all of these pending disqualifications, motions, and writs. I'm not going to stop. I happened to watch police department bribery in Lewiston in 2020. And as such, I've reported that to Patty Weeks, I've reported it to Justin Coleman, and it happened to involve Trey Turner's employer, Traveland RV, which is why Traveland RV wanted to represent Justin Coleman. That's why all of the cases were closed. And that's why we're here today. But despite hearing here today, I'm going to participate under continuous protest, renewing each objection at each stage. I'll cross-examine any witness about procedural conflicts. I'm going to continue to move to compel a Tolleson file if one exists. I will continue to object to any participation by Karen Carlisle, any scheduling, anything that was touched by her, since she is a witness to the intimate relationship working in Nez Perce County. Make no mistake, every ruling against me on these procedural issues simply strengthens my appellate record. The Idaho Supreme Court of Appeals will have to see a clear pattern denying fundamental due process unless those due processes are addressed here today. My core merit issue with Patty Weeks as an incoming bar commissioner and a current bar commissioner, she will oversee ethics cases involving Nez Perce prosecutor Justin Coleman, the same official whose constitutional violation she ignored as clerk of court. The bar rules prohibit this under IRP 1.7, but we cannot even fairly litigate these merits in a procedurally corrupted forum. The structural defects prevent any credible resolution of this substantive of issues. The harm is irreparable, forcing me to expand limited resources defending against charges in a void proceeding is itself a due process violation. The risk of mootness on my pending Supreme Court writs is real. Every day that happens, the public trust in the bar erodes further as these conflicts remain unaddressed. Justice delayed is justice denied. But justice in a corrupt forum is no justice at all. What I want to see from this process is what the Constitution guarantees every citizen: a fair hearing before a neutral tribunal. Right now, I'm being offered the opposite. So my immediate goal is to preserve a perfect record of these violations for the Idaho State Supreme Court of Appeals. My ultimate goal is a system where the bar holds all attorneys, including its own leaders, to the same ethical standards. The June 20th letter proves that they know better. They just choose not to do better. Thank you for your time. I concede the rest of my time.
All right, thank you, sir. All right, Ms. Weeks, you've been previously sworn. You're under oath. You may proceed.
Thank you. Good morning. I appreciate Mr. Schweitzer taking the time to be here with us. There's two different things happening here. There's the procedural portion, which I think the Supreme Court has done a lot to resolve those issues that have come up. Mr. Schweitzer has brought up some objections today. I think that they lack foundation or a basis. To clarify a little bit, I did not actually take the office of Bar Commissioner until July. I was not, and the way it's structured is the first district and the second district are much smaller than other parts of the state. And so the territory that I represent is the first and the second district. And so I actually didn't take that position until July. I have no knowledge.
What day in July was that?
I can't tell you the exact day.
It would be at the conclusion of typically it's at the conclusion of the state bar conference.
Yes, at the end.
Is that when it was?
Yes.
Okay.
I don't know anything about an independent investigation and not having any of that information turned over. I have no knowledge. I will assert that any cases that come before me as a member of the board of commissioners that involve any of the attorneys that are in Nez Perce County, I would recuse myself and not participate at all or have any knowledge or input regarding those. The second area is the substantive part of this. There's two main allegations of ethics violations regarding mainly Rule 8.4, which is A and B. The first is failure to investigate a campaign finance violation and remove a candidate from a ballot. The second is the First Amendment violation for failure to address censorship or blocking of social media in 2023 and 2024. And there's kind of a third area, which is hints of collusion and conflict with the prosecuting attorney, Justin Coleman, and Deputy Prosecuting Attorney April Smith. I am not practicing law currently. I am not supervising anyone practicing law. I have conducted myself in my current elected position as clerk of the district court, 2nd District in Nez Perce County, in a professional manner. And in doing that, I try to respond to people timely when something comes up. So in the record, and this would be, and I'm referring to, just give me just a moment, I've got a couple of these up. The appeal record, which contains some emails, and on page 4 in particular is what I'd like to start with. And this is an email, October 18th, 2023. And it's when I received an email complaint about Maureen Anderson. So just let me give you a little bit of background. 4 years ago, there was a group, a PAC that was created, and their name was Lewiston Smart. And they wanted to change the structure of the city of Lewiston in the government, go from a manager to a strong mayor. And this group, Lewiston Smart, wanted that change. Ultimately, that's what happened. Fast forward to 2 years ago, for the city council race, Maureen Anderson was a candidate for city council. And that's where this email dated October 18th stems from, her campaign and her complaint. So on the 18th at 11 p.m., I received that email, which is on page 4, regarding the First Amendment rights violations, blocking our petitioner on social media. And then on October 19th at 2:53 a.m., page 4 still, is an additional follow-up complaint regarding Anderson's campaign violations and requesting that she be removed from the ballot. And then I did not submit additional information because I think the petitioner did a good job with establishing what actually took place in our exchange. And so on page 5, you will see my response, which was on October 20th at 7:54 a.m., where I said that I'll look into the complaint. And I do that. When somebody comes to me with a problem or a complaint, see what I can do to resolve it or the best way. And then on October 20th, so this would be, let's see, October 20th at 9:38, which is on page 7, I received additional information from the petitioner, campaign contributions. And so he threw a lot at me, which is absolutely fine. I did receive yet another email from him on October 24th in 2023 at 4:02, same page, page 7, where he's requesting a follow-up email. On October 31st, same page 7 at 6:19, I was able to share my research of what I found. And what I found is that the Lewiston Smart Political Action Committee, PAC, did not have any financial activity during that time, and also reviewed Ms. Anderson's financial activity and found absolutely no evidence of such a thing. And so there really wasn't anything that I could do. And then I also tried to address his First Amendment issue regarding blocking social media and a public figure. And that is something that, thanks to his spurring on, we have made some changes in my office. But the prosecutor is an independent elected official. I don't have any authority over him. The only thing I have is I pay him through, that's one of my functions, is to do payroll. Otherwise, I don't have any means to change the prosecuting attorney's behavior. And I don't have any means to change other candidates' behavior for blocking on social media. So what I did was changed our procedures here, and normally when someone files a declaration of candidacy, I give them a packet. It's always better, I think, if everyone is following the law, doing it correctly, and then they can just go on to the substantive business. And so then we started to hand out, with our signed ordinances that we give, information regarding, as a public figure, and your duties to allow First Amendment speech. And so that's what I did. Unfortunately, it was not the answer that the petitioner wanted, but I do think that we did make some good changes within the office to address more modern times. And then when you look on page 9, we have, this is Saturday, March 16th, 2024, 11 p.m., where I received an email that included many recipients. First Amendment violation. There wasn't much more that I could do other than I responded on March 19th at 1:12 p.m. and just acknowledged to thank him for sharing that information. They're just, I understand the petitioner's frustration, but unfortunately I'm just really not in a position to assist and to help him. And so there's really, I was timely, I was professional, wasn't practicing law, wasn't supervising anyone, and held myself, I think, in a manner that I can be proud of as a public servant and as an attorney. And the complaint just simply lacks, against me, lacks any substance. There is no evidence of an ethic violation. Thank you.
All right, thank you. All right, now, Mr. Schweitzer, since Ms. Weeks had presented some testimony, you have an opportunity pursuant to the scheduling order for up to 10 minutes of rebuttal to her statements. So you may proceed.
Thank you, Your Honor. As Ms. Weeks has clearly pointed out, that she does have a financial relationship with Justin Coleman, and that alone is enough to show some evidence of impropriety. Likewise, her claim that she is only an incoming bar commissioner, I certainly take issue with, because right now I am looking at a formal ethics opinion that was published in the commissioner's column of the Idaho State Bar as of the 7th. I understand it's not admissible in court today, but a pen by the commissioner's column, The Tale of Two Courthouses in Nez Perce County by Patricia E.O. Weeks, published by C. Carnes. It clearly states that she is a licensed attorney in Idaho and Washington and currently the clerk of the district court in Nez Perce County. She previously served as an officer and president of the 2nd District Bar Association and is now the new bar commissioner representing the 1st and 2nd districts. This is an official publication by the Idaho State Bar saying that Patricia Weeks has been a commissioner before the appointment. Whether or not she oversees any other lateral districts or whether or not she claims that she would recuse herself is somewhat of a moot point when the Idaho State Bar dismissed the claim before it was even heard. This is going around in circles of far as technicalities and conflicts of interests. This needs to be washed and started from the beginning with a true investigation with the campaign finance violations, of which I could also present more evidence to this court. This was just an initial filing to Patty Weeks. It wasn't meant to be a conclusive and all. Instead, it was dismissive. That, as well as dismissing the complaint that the Nez Perce County Prosecutor's Office then blocked me. She can say that she has limited authority over them as the clerk of courts, which is likely true. But as an incoming bar commissioner, she has a heightened responsibility and duty to uphold the law. And as having a regular working relationship with both of these two gentlemen, Turner and Coleman, she should have an ethical responsibility to immediately stop those shenanigans. I mean, to even suggest that, oh, my authority is limited is what brings us here to your doorstep, Special Master Carrick. As far as any of the other addressed or unaddressed in the complaint, she believes that we had just the 2 of them. Well, she didn't bother to address the blocking by social media by Justin Coleman right after I reported the police department bribery. And as a question to you, Judge, to round out and finish out my statement, exactly which bureaucratic form do I need to file to report the bribery and corruption of 3 sworn officers? Richard Fuentes, Andrew Fox, and Nicholas Woods of the Nez Perce County Prosecutor's Office. I would like to know, please, which bureaucratic form do I need to file?
Okay.
Thank you, and I relinquish the rest of my time.
All right, thank you, Mr. Schweitzer. I do have a question on the timing when you say she, what was unaddressed was the blocking of the social media by Justin Coleman. Now, what year was that? Was that 2023?
That was immediately after the Maureen Anderson conflict,
Okay.
at the beginning of January 2021. Yes, ma'am. And shortly thereafter, I had false charges filed against me by Trey Turner.
Okay, so you're talking about 2021 that you were blocked by Justin Coleman, but then what was the you were also complained about the blocking you wrote the email in October of 2023
Correct.
to Ms. Weeks. Was it referring to new blocking by Justin Coleman or somebody, or blocking by somebody else?
The initial blocking was by a candidate for Lewiston City Council, Maureen Anderson, in October of 2023.
Oh, okay. All right.
Nez Perce County Prosecutor's Office had then blocked me from Facebook for reporting police department bribery on their page in the beginning of 2024.
Okay.
Does that clarify the record for you,
Yeah,
ma'am?
yeah, it does. And I reviewed those emails, but just something you said made me wonder if it dated back to 2021, and I wanted to get that clarified.
Yes, ma'am. That was when I originally reported the police department bribery to the Nez Perce County Prosecutor's Office.
Well, you asked me for direction on how you present or who to present it to. That's something that I am precluded from giving any kind of legal advice or direction in my capacity in this proceeding. That it definitely is not something that is within the context of this action. And so I can tell you that much, but you probably know that already. So those are questions that I think that in terms of your investigation would relate to finding out about officer standards, ethics, that sort of thing, and what kind of boards there may be. But in terms of me giving you specific advice or direction, I'm not allowed to do that, and I wouldn't necessarily have an answer off the top of my head anyway. So the facts always make a difference, and so I would urge you to get either some legal advice or to continue to do some research on that matter. But I at least wanted to give you an answer.
Thank you, Your Honor. I have gone down the normal course of channels and directions, and that's what brings me here asking you that question. It's because the normal channels of redress have catastrophically failed.
Okay. All right, so Mr. Schweitzer, then that concludes your presentation in terms of, you said that you cede the rest of your time?
Yes, ma'am.
And Ms. Weeks, you can present Sir rebuttal or not, it's up to you.
Just one clarification for the record. And the petitioner was referring to, I was the bar president, the local bar president. So that would have just been for the District 2, and it's been many, many moons ago, and which is separate than bar commissioner. So each district, there are 7 districts, and each district have a local bar president. And then that is just a network of the local attorneys. And the bar commission is a statewide organization, which has 5 board members, which makes up representation of some of the districts. And so,
about how many lawyers are in the 2nd district? Do you have a ballpark number?
About 247. And this
currently, or you said you were bar 2nd district bar president some years ago. Do you have an approximate date?
In the 90s.
Okay.
And that's all I have.
All right, thank you. Okay. I don't believe that I have any additional questions. And so I want to, at this time, close the record in this proceeding, subject to as I said, we're perpetuating the testimony today. Depending on what the Supreme Court may be doing on the pending motion on the order to show cause, and how it relates or doesn't relate to this case, then I'm not going to make a decision and issue a written ruling or written decision until that matter has been determined. So I'm basically keeping it open in case there is something procedurally that changes. But if it doesn't change, I'll make a record on that, and then we'll issue the decision within 21 days of the date that the Supreme Court rules on the order to show cause. And I'll do an interim order that clarifies this so that you can make reference to it. But basically it is that if nothing is relevant or nothing changes, then I will proceed with the written ruling, written decision. If there is something that changes based on the Supreme Court, then we will hold this in abeyance and determine what would be appropriate procedurally moving forward. But at any rate, we're able to get some closure to this point and on the issues that have been raised. So, Mr. Schweitzer, thank you so much for your presentation today.
Thank you for your time.
And Ms. Weeks, thank you as well. And so we will go off the record. This concludes the hearing.
Thank you.
Recording stopped.